Welcome to Healthcare du Jour, where we dish up and digest the latest in healthcare. For the next 30 minutes, sit back as we bring you insight, commentary, and discussion on trending topics to the table, all expertly served up by our host and his guests. Healthcare du Jour is brought to you by Carium, the telehealth platform enabling healthcare's digital transformation, helping you care for people within the fabric of their daily lives. Now here's your host, Matt Fisher.
Welcome back, and thank you for joining as we dive into the hottest topics in healthcare. I'm your host, Matt Fisher. On the menu today is Andrew Mahler, Vice President of Privacy and Compliance at Clearwater Compliance. Andrew, welcome to the show.
Thanks so much for having me, Matt. I'm really happy to be here.
So, Andrew, what I always like to do before getting to the main part of the conversation is to give my guests a chance to provide more of an introduction in terms of who they are and what they do. So the floor is yours.
Sure. Thanks, Matt. So I really started my career in this field. Actually, while I was in law school, I served as an intern for the Office for Civil Rights. I worked out of the Atlanta office, which at the time was Region 4, and then spent a lot of time as an investigator there after law school, and worked on lots and lots of privacy, security, breach notification, and some civil rights cases while I was there. I then left and built privacy programs as a privacy officer and a research compliance officer for a number of universities and academic medical centers, and then landed with this company. And I've been with Synergistic, which was recently acquired by Clearwater, about 6 years, and have just really enjoyed the time that I've spent getting to know lots of different entities and organizations over the years.
So I know you just said you went to OCR kind of right out of school. Was it always your intention to get into healthcare, or was it just a happy accident?
It was. I had, prior to law school, I worked for a couple of years for Blue Cross plans and worked specifically in the marketing department, helping to manage some of the regulatory issues around sales and marketing. And I knew at some point that I wanted to really broaden what I was doing, and issues like data protection, cybersecurity were really starting to gain a lot of traction. This is probably 10, 15 more years ago, and it was something that intellectually was just really, really interesting to me. So it was always kind of in the cards, but was really thrilled with the opportunity to work with OCR.
Understanding it was probably a little bit of time ago, and then that you can't give away all the secrets. But what was it like being on the inside of OCR, and kind of what did the investigations look like at that time?
Sure. When I was there, it was a bit more of what I think people called the sort of voluntary compliance mentality. There weren't a lot of fines at that point, and actually I worked on the first $1 million resolution agreement while I was there. So it was, the mentality, the enforcement, approach was shifting while I was there, and it was interesting to be a part of that. I would say that, many investigators, you're really spending your days going through lots and lots of cases. And so, those of you who are listening who may have submitted a notice to OCR, may have received communication, you've probably experienced lots of communication gaps and lengths of time in between communication. And really that's because these investigators, they're usually overloaded, and they have a backlog of cases they're working through. So it was, we had a lot of fun. It was interesting. Really, of course, served as a great, foundation to really understand how some of these requirements and ethical issues get operationalized by organizations, and again, had a good time while I was there, and I was also excited to go out in the field and start building on my own.
So how did your experience at OCR influence your approach to designing and building privacy and security programs?
It influenced it, I would say, very, very substantially. So, I think first of all, really having an understanding of how the rules and regulations are interpreted by investigators and offices and by the agency itself, is certainly something that's very helpful. As is some of the foundational elements that a regulatory entity is looking for when it investigates an organization for noncompliance. So, really coming into organizations, especially those where we're helping to build programs or design programs, we're really thinking first, what are some of the foundational aspects to what makes a privacy program successful, what makes it really impactful to the organization and really helps protect the privacy and security of patients. And that's policies, procedures, training, all of those things.
And kind of thinking about that, and I think implicitly, although I don't know if we've said it explicitly, I think a lot of the discussion so far has been kind of focused upon HIPAA, but on top of HIPAA or in conjunction with HIPAA, what are some of the overarching privacy principles that healthcare organizations should be paying attention to now?
That's a great question. Something that we're hearing more and more from clients, and I'm hearing more and more from my colleagues out in the field. Really, the way that I sort of conceptualize this question around data, protecting data, regulatory risks is I think about data in terms of categories. I think about organizations in terms of categories. So, is this derived from a covered entity? Is the data coming out of an EHR? Or is the data coming, from a consumer health perspective, coming out of, health apps, health devices, even websites, things like that? Or is the data really derived from, I guess I would say warehouses or other sources that may not even be in the health space, but may have health data. So in each of those categories, so again, whether it's coming from, an EHR, an EMR, coming from, devices, or coming from other sources, there's different types of regulatory requirements that apply, and it can create a pretty complex patchwork for legal and compliance offices.
And when you're talking about that patchwork, is it fair to say you're talking about a patchwork of varying federal and state laws?
Yes, that's right. So HIPAA is as you mentioned, HIPAA is usually the preeminent, the prominent rule and regulation that we're thinking about in this space. But of course, we've seen the FTC get more involved in the space as well. They've really looked at they've looked at this concept of unfair and deceptive trade practices, and they've honed in on privacy policies and really holding organizations to their privacy policies. Of course, then you have state law requirements, you have international law requirements, and then an interesting I would say it's not really a side law, but a side piece of the conversation is 21st Century Cures Act, because there are some aspects to how data is accessed and disclosed that are certainly impacted by that as well. So there really is a number of larger rules that are out there that we're thinking about.
Yeah, no, I think that's a great point, because your reference to 21st Century Cures and the information blocking regs in particular, where I think, as you're alluding to, expanding access, but at the same time, I remember as those are being proposed and then finalized, there was concern: are the requirements in conflict with some of the privacy protections that HIPAA or some of the other laws that you were referencing would call for?
Yeah, it's exactly right. I mean, there are a number of, as you mentioned, the information blocking rule. There's a number of exceptions to that rule, and some of those exceptions help guide decision making about whether and how data can be released to people. And of course, when you're thinking, more broadly about data protection and privacy, that type of access and disclosure is certainly something that really is top of mind.
Yeah, and kind of thinking about that access and the exposure, how has the growth of, I guess for a lack of a better way to call it, non-traditional healthcare entities or solutions kind of changed the discussion?
I think that, if I assume you're talking about things like, devices and health applications and those sorts of sources, is that sort of where you're headed, Matt?
Yeah, definitely. Like consumer wearables, or, a lot of those called, virtual care solutions, where they're trying to get direct to consumer. Sure. And are, I think, from their perspective, breaking the traditional pathways and trying to make it easier. But then, from I would say a legal or compliance perspective, yes, they're breaking it, but they're breaking it by falling outside of the system where a lot of those regulations existed.
Yeah, I think this is an important place in the discussion to really start thinking a bit more broadly about the ethics around data privacy and data protection, because you're right. I mean, there are a lot of organizations and entities and applications that are taking lots of information about our health, and some of it's very sensitive. And those entities, they may not have obligations under HIPAA. They may not even have obligations under state law requirements, and so they're really operating in what could be a bit of a gray area, at least until we have some sort of a larger privacy rule or law that really helps bridge that gap. And so I think because they're operating in some of these more gray areas, we're really seeing a lot of people, both consumers as well as organizations, thinking about the ethics of the data collection and data disclosures. They're thinking about risks to reputation, and as well as just really wanting to make sure that information is secured. However, you have other applications and companies out there that are interested in collecting as much as they can and monetizing it and selling it, and it really underscores the importance that I think we've started to note over the years of an individual really taking ownership of the data that they choose to put out in the world.
Yeah, and as you're referencing the ethics, can you walk us through what some of the ethical considerations are, and how that either differs or expands upon the legal requirements? Because I think it's at least from an attorney's standpoint or other places, you understand that there is a divergence between ethics and law. Yes. And that the ethical thing to do isn't always the legal thing to do, and the legal thing to do isn't always the ethical thing to do.
Right. Yeah, I mean, it can be very complicated, and it's going to, it really is in the eye of the beholder, right? And there's a lot of room to grow and move within the ethics space. I think people tend to think of it, and at least in the data protection and cybersecurity spaces, do we really need to collect all of this data that we're collecting? Do we really want to? Because maybe we're collecting data about people that's very sensitive, that even though we may not have certain legal or regulatory requirements, can be damaging or harmful to people. Are there things that we can do as a company to protect and secure that data, so that we're not inadvertently or even purposefully harming our, whether they are consumers, people that purchase or participate in our organization or technology. So it's really, at least in my mind, it's really taking a holistic look at data, and you're really asking questions like, why do we need the data? What type of data do we really need? And are we collecting more data than we need? And does that data present unnecessary risk to people that rely on our services? Yeah,
no, I think as you're saying, it's, don't just collect data because you can collect it, but take a step back and, actually do a meaningful assessment of what your business model is, and then build around that.
Yeah, that's right. I think there's been there was a period of time, maybe 10 years ago, where I think especially web-based companies were really, they were really coming at the market and saying, we want as much information about everybody as we possibly can get. And, I think what many of those organizations have found over the recent years is that just collecting, all of the data that they can collect, often results in harm, not just to people, but also to the organization. We're seeing more lawsuits arise around data protection and cybersecurity breach issues. And we're seeing organizations that are starting to, think a bit more strategically about the data they're collecting and what they're doing with it.
Yeah, no, I think those are all very fair points. And for those of you just joining, I'm talking with Andrew Mahler from Clearwater Compliance. We're talking about kind of privacy concepts and ethics of privacy. And kind of as we, given that discussion around ethics and, asking the question of, do we need to be collecting all this data? What should we actually collect and how should we protect it? I think that's kind of a good way to pivot in a direction of, what is arguably now the elephant in the room, which is how did the world change when it comes to privacy after the Supreme Court's decision in Dobbs?
I think the answer is still a bit unknown, but we certainly have seen conversations become incredibly activated. I think before Dobbs, we saw, as part of the legal and regulatory conversation, people saying, well, we know that your personal data could be abused. You could be harmed by data if it gets in the wrong hands, or if bad actors get access to it. But we've seen courts and others kind of struggle to really understand, what really is the harm to people, and what could actually happen if sensitive data gets in the hands of other people. I think the Dobbs decision has really highlighted some areas that created a lot of anxiety for people around data that may not be protected by HIPAA, but data that can be used to prosecute people, potentially can be used to identify people and really make people vulnerable and within the health space, and particularly related to very, very sensitive data.
Yeah, and I guess kind of from that decision, what other misconceptions or misunderstandings around protections that people thought existed have you found kind of come to the fore and help to explain where privacy might not be as complete as might have been thought?
Yeah, I guess I would even go even a little further back than Dobbs, and I think with the COVID-19 pandemic, we started to see the public become a bit more educated about HIPAA, because we had this sort of national conversation about whether or not HIPAA applies in certain circumstances related to COVID-19 and treatment and diagnosis. Dobbs, of course, has highlighted that again, and we're seeing questions about, well, does HIPAA really apply to certain types of data? Does HIPAA apply to certain reproductive health organizations and centers? And we're seeing people be a bit more think a bit more critically about how their data is or isn't being protected. This, of course, has led into a much more recent conversation around tracking technologies and how websites and applications are collecting data about us, and how that data can be used both for bad purposes, but it can also be used for permitted purposes, like disclosing to law enforcement, disclosing data about people to others pursuant to a subpoena that could actually harm people, depending on the jurisdiction you're in and where you reside.
And that's a great point too, because it's for pretty much as long as HIPAA has existed, there's been that ability for law enforcement, or in a lot of situations, for health information to be used to disclose. And it's I also like the point that you made about the pandemic, going to the start of it. I used to shake my head all the time because I would track HIPAA as a keyword on Twitter, and it made my seeing comments on it would almost make my head hurt on a daily is probably not even frequent enough. But I think also brought it around to, I think, as you said, it drove critical thinking about what are the protections in reality and what can be done to help improve it.
Yeah, well, to your point, I was doing the same thing, and you were seeing people, engage in Twitter and social media posts about what HIPAA does and doesn't protect, and people correcting other people, and sometimes trying to correct them, but providing bad or incorrect information. And we started to at least see some dialogue that I think up until that point, people knew about HIPAA and understood that it protects some type of medical information, but I think we had a bit more of a mass education. I don't know if that education really settled in or not, but we certainly saw more people talking about it then. And then after the Dobbs decision, the anxiety just really went through the roof.
Yeah, no, I think the whole kind of conversation really reinforced how I always like to describe it. I would always call HIPAA the Miranda rights of healthcare, where everyone's heard of it, but no one knows what it actually does.
Yeah, it's a great way to put it, Matt.
So, but thinking about the conversations that you were talking about, where do you see the privacy discussion going? And, what changes do you think could be implemented to either better or more appropriately reflect a lot of the concerns that you've been talking about, whether it's because of dogs or just the rise in the ethical thinking about privacy that we were talking about earlier?
Yeah, I think there's a few ways that this could be or potentially will be addressed. I think there's no question that companies are already responding to some of the anxiety. I mean, we've seen, Google has agreed to create some of these areas. I think they're calling blackout areas around certain reproductive healthcare clinics where they're not tracking certain types of data about people. So we're seeing, on sort of the organizations themselves trying to take some initiative to respond to some of the anxiety that exists, fears that exist around, all of the data that Google has about us, for example. I think we're also going to continue to see policy level discussions, both at the federal and state level. Of course, we saw a good bit of headway. I mean, Matt, as you know, last year, around a potential, federal privacy law, and of course that didn't ultimately go anywhere. But we have the foundation for further discussions, during the next congressional session, and hoping that we'll see some really thoughtful discussions at both federal and also within state legislatures around, how organizations must protect and secure data and what what requirements exist around, the collecting of certain types of data. Because again, just kind of underscoring the point that I think we're talking about is that, data, health data in particular, it can be very sensitive. It can be very personal. It can, people can lose their jobs because information about their health gets disclosed. They can lose their insurance if information gets disclosed. They can, it can impact them in litigation hearings and within, custody discussions. And so there's a lot of harm that can be done when data, gets into the hands. Again, we're not really even talking about malicious actors, but when data gets into the hands of just others in general and what others can potentially do with it.
So do you think there's any particular guiding principles that you'd like to see, considered as those discussions around policy occur? And, as you alluded to in the last Congress, there were a couple of privacy bills and one seemed to be coming to the fore. Obviously the kind of the floor gets reset now, but, just from that broader policy perspective, what would you, in an ideal world, like to see help drive better privacy protections or more aware collection activities?
Yeah, I mean, it really gets like the $1 million question, right? It's, there are so many things that can and should be done from my perspective. One example is we have a number of agencies. We talked about OCR earlier. We've mentioned the FTC and certainly, states have various committees and offices stood up to protect data and really respond to breaches and incidents. But many of those agencies are really understaffed. They're really underfunded. And what that means is they're not really able to go out and do a lot of enforcement, provide a lot of guidance and education, help people understand what is or isn't protected. So I would say just at a basic level, I would really like to see, more funding for the agencies that exist now. I think we also have to think much more broadly about what data, how data can be used to identify people and how data should be protected. So we need to be thinking much more holistically. We have examples, of course, like GDPR and even examples like what we're seeing in California with CCPA and now CPRA, where we have mandates to protect data that may fall outside of HIPAA, that may not be PHI, but we have we have mandates and requirements about how it has to be protected. So, I think there's a lot of ways this can be addressed. I think, unfortunately, we're sort of beyond the point where, where we don't need some sort of policy intervention, because I think we just have had so much time, so much time has gone by where people and organizations have just, at least in my opinion, have really skirted the ethical lines around collecting and disclosing data about people.
Yeah, and it's even beyond the concerns about the ethical stance of some of the practices, just given some of the larger societal and I guess political factors that we were also talking about. Not having something that's just voluntary, but having clear legislative and regulatory guidelines really kind of just would hopefully prevent either side from trying to play games around it, because there would then be guardrails that you can't get around.
Yeah, I mean, there really do need to be. I mean, I think guardrails is a great example, a great way to put it. We do need to have a framework where people know exactly what has to be protected and secured, and they have to know that if that isn't protected and secured, that there are going to be, things are going to happen. There's going to be penalties or fines or corrective action plans. Because if, the FTC is maybe a good example where, I think people have sort of conceptualized for a while that the FTC could really do more in this space. And I think they're certainly moving in that direction. But, I think without having that, that particular agency really activated, there's uncertainty and about what needs to be done and what's going to happen if they don't do it, right? So
yeah, no, I think that's a great point. And unfortunately, we're already almost out of time. So I'm just going to close with one final question, which is,
sure.
What do you think is the biggest opportunity when it comes to privacy in the coming year?
I think we have a lot of opportunities that have been presented to us. I think one main opportunity that organizations have is to really start considering thinking about data more holistically. I think especially in light of Dobbs and some of the tracking technology discussions that have happened, it's going to be vital, and it is vital for organizations to be thinking very critically about what they're collecting and how they're storing it. And I think just in general, I think from a personal perspective, I think we all have an opportunity individually to think more critically and think a bit deeper about what we are doing with our data, what we're turning over to other companies and organizations, and whether or not there are things that we can be doing to really think a bit more critically about providing data to people about ourselves.
Yeah, no, a lot of great food for thought for folks. And as I said, believe it or not, we are already out of time. I want to thank my guest, Andrew Mahler, for a great conversation today.
Thanks, Matt. It really was a pleasure. And, time went by very fast. So great talking with you.
Yeah, no, and thank you to everyone listening. Keep the dialogue going and connect with me at #HCDEJURE. I'm Matt Fisher. Until next time.